This half hour, a civil lawsuit filed by families of the victims of the Tops mass shooting took another step forward. A judge has denied the request from social media companies to be dismissed from the suit.
Joining us now to talk more about this unprecedented ruling is Kristen Elmore Garcia, an attorney representing some of the families. Kristen, thank you so much for joining us here.
Thank you for having me.
First of all, congratulations. This is a very big win for any attorney, certainly one locally here. Let's catch some folks up if they're not familiar, because there's a lot of lawsuits and a lot of legal wrangling going on around this case. Let's talk specifically about this civil lawsuit involving these social media companies and what the judge ruled this week.
Around May last year, our office filed the first lawsuit of its kind in the country to hold social media platforms accountable for what they have as a dangerous, defective product and their policies and online practices that cause real-life harm and real-life damage to our community here in Buffalo. As to be expected, those companies filed motions to dismiss our lawsuit, and just yesterday, the judge ruled against those motions to dismiss, denying them in their entirety and allowing our lawsuit to proceed.
And that is a really big deal, because the reason why this is unprecedented is, unfortunately, in our country, we have to deal with these mass shootings. And so often, social media is involved with the gunman or gunwoman. Most of the time, it's a gunman. So here we are, because in every situation almost, these social media companies are sued and their dismissal is upheld. Was there a reason the judge in this case decided to uphold, was not going to grant their dismissal in this case?
The decision was decided on very narrow grounds. The judge had to answer the legal question in our summons and complaint: was there any cognizable legal theory that would hold up? The standard that she had to apply was to give our side every favorable inference. Based on that narrow question that she had to answer and that very favorable standard that she had to answer, she ruled that it's just not the appropriate time to dismiss our case. Some of the things that the social media companies, some of the facts that they're attempting to bring out, she specifically stated some of those facts may be true, but now is not the time to address them. Now's the time to proceed with discovery, which is sharing evidence and information.
Kristen, you mentioned how this lawsuit, it really is one of its own kind. Yeah. Really, from a general law standpoint, why is it so difficult to go after social media companies compared to, what this lawsuit is really focusing on?
The social media companies have a protection that's almost unlike any other industry. The car industry, if they make unsafe cars, you can sue them to hopefully that they'll make changes in their product design and make safer cars. The alcohol industry, they can't just sell products on our consumer shelves that are dangerous. But the social media the social media industry, for some reason, has special protection under the First Amendment, but also there's a specific federal statute, Section 230 of the Communications Decency Act, which it really only protects for third-party content posted to their platforms. Our lawsuit's not based on third-party content. Our lawsuit is based on the intentional, profit-maximizing policies and practices that these corporations do that have real-life negative impacts on our community.
You mentioned a word before, a legal term that we hear sometimes, and that is discovery. And that means now you and other attorneys will have access to information, sometimes proprietary information, of some of those social media companies. That is a big, big win in and of itself, because now you have the ability to depose and question certain people within those social media companies?
That ideally would take place next. I don't think it's going to be without challenge that we're going to get to obtain all the discovery that we want. I've already heard from some of the major social media companies that they do plan to appeal this decision to the next level of court up, which is in our state, that would be the appellate division in Rochester.
Now, this really is a big win for you and the families. What was their reaction when they learned of this decision?
The reaction was one of joy. It's one of, we're getting to the next stage. I was very careful in explaining to our clients that this doesn't mean that we win the case, but it just means we're not out for the count at this early stage.
And that is so big. But you're also telling your clients, because we've heard from you before say this, not to expect things to happen tomorrow. This is a lengthy process, but this is a big, big win. Do the families get energized by this ruling?
I think so. There was a lot of celebration over the phone yesterday. It's like I said, it's the first decision of its kind ever in this country to hold social media companies hold them to have some skin in the game, that they have to answer for some of these policies and what they're doing to our youth and our community.
Wonderful. Well, Kristen, thank you so much for taking the time to join us this afternoon.
Thank you.